Under the Administrative Procedure Act, or APA, an agency must comply with notice and comment procedures if it creates a substantive rule. But what's a substantive rule? The APA doesn't provide a definition, so we'll look to the holding in Professionals and Patients for Customized Care versus Shalala to see how courts determine whether an agency's rule is substantive and requires notice and comment procedures. Drug manufacturers are regulated by the federal government. But drug manufacturers aren't the only companies legally permitted to create pharmaceuticals. Licensed pharmacies can create drugs through traditional compounding, the process of mixing ingredients to create unique medications for individual patients. Licensed compounding pharmacies are regulated by state law, not federal law. The Federal Drug Administration, or FDA, discovered that licensed compounding pharmacies were buying drug ingredients in bulk and creating drugs without having prescriptions for specific customers. The pharmacies would then market and sell these new drugs to consumers and practitioners. The FDA believed that these pharmacies were participating in large-scale speculative compounding to circumvent the federal oversight required for drug manufacturers. In light of this discovery, the FDA created a compliance policy guide that outlined 9 non-exhaustive factors that the FDA would consider when it determined whether to initiate an enforcement action against pharmacies participating in large-scale compounding. The FDA implemented this policy guide without holding a notice and comment period. Professionals and Patients for Customized Care, known as P2C2, sued the FDA, represented by United States Secretary of Health and Human Services Donna Shalala. P2C2 claimed that the compliance policy guide was a substantive rule, so the FDA was required to have a notice and comment period. The FDA argued that a compliance policy guide was a non-substantive rule. The district court agreed and ruled in favor of the FDA. P2C2 appealed.